Next, I'd like to introduce Heather Wilson. Heather is a litigation partner at Frost, Brown Todd in Indiana. Heather is listed in Chambers USA, Indiana Super Lawyers, and is a distinguished fellow of the Indiana Bar Foundation. Her experience includes ADA cases, Title VII cases, age discrimination and Employment Act cases, natural origin discrimination cases, wrongful discharge and retaliation matters, as well as non-solicitation cases. She advises clients and human resource professionals in all areas of employment law. Here to talk to us today about plaintiffs' use of documentary videos is Heather Wilson.
Good morning. So with that introduction, you're probably all wondering, what in the heck is an employment lawyer going to be talking about discovery of settlement documentaries? Because in employment cases, we don't really have catastrophic injuries, right? I mean, if we have injuries at the workplace, it's called work comp. But no, this is something that we as litigators and see plaintiffs' attorneys using more and more often, more in right before a mediation or playing it at a mediation in these, specifically the catastrophic type cases. So what is a settlement documentary? Basically, it's a video that is usually a tabloid kind of production that attempts to address liability and damages in the particular case, but it takes those facts and unreasonably presents them in a light in favor of the plaintiff. And we've seen in these types of settlement documentaries the use of demonstrative recreations, medical imagery, day-in-the-life footage, for example, but also, and this is the key piece here, is that they also include heavy edited interviews of key third-party witnesses, experts, and physicians. So what are some of the companies who produce these documentaries saying about them? Well, if you look at, for example, we had David Stafford, who was quoted in the Indiana Lawyer fairly recently, and he claims, and I put a couple of quotes here on the screen, all of our documentaries are authentic. Interviews are unrehearsed, and people on camera are not coached. The words they're saying are sincere, not canned. It's not something that's scripted. I don't think any other medium besides video can capture that. So, obviously, there's a difference of opinion on that, being a defense lawyer. And the key I want to focus on for the next few slides is this authenticity. This is the key that renders some of this unedited footage that I was referring to earlier potentially discoverable. So as a defense lawyer, obviously you're very interested in understanding what this unedited footage might contain. And when you go and you ask for this unedited footage, there are some objections that you're probably going to run into, and maybe you've run into in dealing with these sorts of issues. The first one is the plaintiff is going to object on the grounds that this is shielded by the work product doctrine. However, if you look, and obviously we're from various jurisdictions here, if you look from multiple jurisdictions, there are cases out there that suggest that this unedited footage may not be subject to the work product doctrine. Just real briefly, what is the federal work product doctrine? I mean, in general, the federal work product doctrine is intended to maintain legal professionalism by precluding attorneys from capitalizing on an adversary's work efforts. And if you look under Rule 26b3, It generally precludes discovery of materials that are prepared in anticipation of litigation for trial or by another party or its representative. However, what's very important to note is this rule does not protect underlying facts contained within the work product. So, it's very important to drill down into this rule and this privilege, this doctrine, and distinguish. Again, federal courts consistently hold that notes, memorandum prepared by the attorney or the attorney's agent for witness interviews are going to be subject to the work product doctrine. However, numerous federal courts have found that verbatim, and that's the key, verbatim non-party witness statements are neither privileged nor under the work product doctrine and therefore must be produced. In fact, there's a recent case which is the Milwaukee Concrete Studios case where the court took this concept one step further. In that case, it's an Eastern District of Wisconsin case. The district court permitted discovery of an audio tape conversation between the third-party witness and the plaintiff's attorney. And when the court looked at that whole and analyzing that holding, they basically equated the audio tape conversation to be considered similar to unedited footage from a witness interview. So again, looking at these cases, you can analyze or analogize that these audio tape conversations, like in the Milwaukee case, is really similar to basically a verbatim recitation of a fact witness interview. Therefore, there's a strong argument that these sorts of things should be discoverable and are not subject to the work product doctrine. So, in addition to arguing or asserting that these settlement documentaries are not subject to privilege, you also need to look to see if there's been, if the court does hold that there is some sort of protection, if there's been some sort of waiver of the work product protection. And just going back real quickly on what waiver is in the work product arena, it occurs when covered materials are used in a manner that is inconsistent with that protection. And I've cited kind of two examples of waiver: implied waiver, which obviously occurs when a party injects the substance of the work product into the litigation. But then second, subject matter waiver can occur when a party makes a partial disclosure of a work product while seeking to maintain protection of a work product related on the same subject. Again, going back to this unedited footage that we have in these settlement documentaries. So, when plaintiff's counsel wants to just show certain portions of these third-party witness interviews, a particular version of the facts, if you will, I would argue that they've waived their right to assert work product protection, and therefore it makes this unedited footage relevant to the subject proceeding. Now, in addition to arguing work product, plaintiffs will also bring arguments that these statements are not discoverable because they're basically inadmissible under Rule 408. And obviously we're fairly familiar with that. Things that are said, statements made during mediation, compromise negotiations are not admissible. There's also state-specific laws that apply here. So that's another argument that plaintiffs make, is that, look, these are things that we prepared. as part of the mediation process, and therefore they're not discoverable because they're never going to be admissible. But if you look at what Rule 408 states, that argument, it just isn't supported by the specific language. Rule 408 only excludes statements when they are used to prove or disprove the validity or amount of a claim, or to impeach the party with a prior inconsistent statement. So that argument that these should be precluded under 408 basically ignores that these statements can be admissible for other purposes, and specifically for disproving a witness's bias or prejudice. Finally, we've got a case recently, the Horner versus Carter case in Indiana, where they've recognized that these statements made during the course of mediation or other forms of ADR, while not necessarily admissible, may lead to the discovery of admissible evidence. So there may be similar cases in your jurisdiction that also hold that same principle and that you could use to rebut that argument that they're not admissible under 408. So I want to talk a little bit now about the difference between a settlement documentary and a day in the life video. Despite there being a lot of federal precedent out there in favor of discovery, at least one state Supreme Court has held that unedited portions of a day in a life video constituted a work product and therefore was not allowed. This is the SuperCourse, I think I'm pronouncing that correctly, case versus Palace Community Hospital from the Illinois Supreme Court. And in the SuperCourse case, the plaintiff's counsel was filming a day in the life video, and prior to filming, the defendants asked if they could obtain a protective order from the trial court, giving them advance notice of the filming. They wanted to have the right to be present at the filming. They wanted a copy of the finished film, as well as all of the unused footage. And the trial court allowed defendants to have that. And so that order was appealed, and it went all the way up to the Illinois Supreme Court. And the Supreme Court basically said that the so-called day in the life movie was merely a type of demonstrative evidence. The court likened it to a photograph, a graph, a chart, a drawing, a model, all those demonstrative exhibits that you use at trial, and that because of that, this preparation falls squarely in the work product of the lawyer that had prepared this, and therefore they overturned the trial court's order. The court held that the defendant's counsel had no right to intrude into the production of this demonstrative evidence, and that the test of this evidence will occur when and if it's offered into evidence. Seems to fly in the face of the role of discovery. So, as you can imagine, there was a dissent, and a very strong dissent. And just a few pieces that I want to share with you from that. Basically, the dissent said, look, the majority opinion ignores the proper role of discovery in the litigation process. Under the majority's reasoning, basically, the defendants wouldn't have any right to review those things until it was allowed to be admitted in trial. And so, how is that fair? That flies in the face of what the role of discovery is. The dissent went on to state that this whole issue of maybe the evidence might come into play later does not mean that the defendant shouldn't have the opportunity to review it and be able to prepare a defense to it. Basically, the majority opinion, according to the dissent, strips the defendants of the full range of discovery opportunities which they are entitled. So I think what we can learn from this is when seeking unedited footage from settlement documentaries, it's important to differentiate these day-in-the-life videos. Unlike day-in-the-life videos, settlement documentaries are much more than demonstrative evidence that the plaintiffs are going to use. Basically, they attempt to skew pertinent factual issues and legal issues that, again, bolster the plaintiff's case. It's very important that we make this distinction. So, in looking at the SuperCourse case, I think it's important that you keep in mind you're going to have to argue that by denying the ability for you to have this unedited footage, that you are in essence precluding your ability and your client's ability to use this unedited footage in cross-examination at trial, to test the veracity of witnesses, to expose any kind of potential biases. The court is precluding your ability to do that. So again, when seeking the production of these settlement documentaries, it will be necessary for you to distinguish these types of documentaries from the typical day-in-the-life videos. Finally, I want to bring your attention to a recent case in Indiana that dealt with settlement documentaries. It's the Rosenbaum case, and in that case, the plaintiff had produced and prepared a settlement documentary that included herself, her friends, her family, and they were all interviewed by her attorney. And as part of the discovery process in that case, the defendant served typical requests for production of documents on the plaintiffs. And the specific request included any and all video taken in creating the settlement documentary, including all materials that were edited and did not make the final copy of said video. And sure enough, plaintiff's counsel objected and saying, look, this request is protected by the work product doctrine, and it was made for purposes of the settlement negotiations. Ultimately, in the Rosenbaum case, the district court held that the raw footage was protected by the work product doctrine. However, it's very important, I think you can distinguish this case for two primary reasons. One, first of all, in the case, the defendants, didn't even contest the plaintiff's description of the raw video footage containing counsel's mental impressions, conclusions, opinions, and legal theories. So in other words, didn't even come back and try to make the argument as to why it wasn't subject to work product. Don't know why, but they didn't. Second, instead of limiting the request that was originally made to plaintiffs, the request basically required unlimited footage from third-party witnesses, interviews, defendants. They requested all unused video. So in other words, if they had been more specific in their request and just requested information about the third-party videos with witnesses, it might have had a different outcome. So while in Indiana we're not real thrilled that this case is out there, we think that we can distinguish it primarily for those reasons. So just real quickly, when you're dealing with these settlement documentaries, just make sure that you look out there. There are federal case law out there that will provide you with support that this footage is basically a verbatim non-party witness statement and therefore shouldn't be subjected to the work product protection. And then to the extent that you can, if it's found to be work product protection, the plaintiff has waived that protection by basically interjecting parts of the video into litigation. Thank you.